Okay, so last session of the day, anti-money laundering and counter-terrorism financing comes to real estate. I'd like to introduce Matt Dunn, General Manager, Advocacy, Guidance, Governance, Queensland Law Society. Thanks for joining us, Matt, and I know you're always open to thrashing out some of those tricky questions, even the ethical ones as well, and no doubt this one after today too. So thank you very much for joining us. And also to Lana Nadge. Lana is Nadge Advisory for the Law Council of Australia. And we were going to introduce Neil, but he's in Auckland. It's a shame because he's pretty entertaining and I think he would have been really engaging on this because New Zealand has been subject to an entire regime for about 5 years. So yes, the Kiwis across the ditch are ahead of us on this one. But we won't hold that against Neil because we have got a bit of a video to show you a little bit later in the proceedings that'll let you know where New Zealand's up to and just give you a bit of background as well. So you do still get to see Neil. And I know, for instance, that Nicola Blade, Head of Risk at McCullers, has been talking to Neil on this particular issue because he is very ahead of the game. So I'm going to come down and hang with you guys. Okay. We're going to do our best. These two actually already told me that they are a duet, so I need to work out how I become a trio with them, but I'm going to do my best because I think they are already pretty on top of their game in relation to this. But I'm going to hand over to you first, Lana, and just have a chat about what we're going to look out for.
Great, I think. Great, thanks so much. So thank you for the opportunity to come and talk to you today, and thanks Kristen, Wendy, for all your work organising the session and all the rest of the ones that we've had today. So why do we care about money laundering? I think probably the last thing you want to hear about between the end of all of those sessions and conference drinks is human trafficking, but it's an area where the statistics are truly horrifying. It's estimated to be one of the most profitable crimes in the world, and the estimate from Anti-Slavery Australia is that 1.2 million children are trafficked every day. It's a crazy, crazy figure. In the UK, some people may or may not know, but the athlete Mo Farah was in the media not too long ago. He was sold in his infancy by traffickers after escaping the civil war in Somalia. And really, his story is very moving and highlights the reality of modern slavery in Europe. We know that in Australia that takes forms that include forced labour, forced marriage, and traffickers prey on vulnerable people and displaced people, and we know that the world is full of displaced people and also those who are vulnerable. So drug proceeds which create cash are connected through organised crime networks to trafficking, but also to weapons trade, and can be reinvested into further criminality as well as into legitimate businesses. In global financial centres like London, people would be well aware that sanctions are another tool that is used to stop dirty money from flowing into the legitimate economy. So Australia's got plenty of drug money sloshing around, we're told by the intelligence agencies, and people probably know that anyway. The government cites the figure of 57.5% of seized assets being attributable to real estate. So it's highly relevant to this audience, and no one wants to be unwittingly facilitating criminal conduct, obviously, especially with the kind of ramifications that I've just mentioned. In New Zealand, there's a case of a gentleman, a lawyer who's, a lawyer, whether wittingly or not is a question, but who is in jail for having done some work that, as it evolved, became clear was actually work for the Comancheros bikie gang. So this is a very real threat. So there are reasons to care about why and how your practice can be proofed against exploitation. I just want to briefly say that at a conceptual level, money laundering is often described as having 3 stages. placement, layering and integration. Placement is where the dirty funds enter the legitimate economy, and examples might include breaking down a large sum of money into smaller funds and maybe using a smart ATM to funnel them through. And layering is the associated process of moving the money around and in that process disguising the illegitimate origins. So if you're the criminal, that might mean engaging a front person or a business to deal on your behalf. And integration is where the dirty money appears clean. So that's the final stage, and that might be false invoices, might take the form of false invoices being issued to generate seemingly legitimate payments, for example. So in our context here, what might this translate to? So the international literature has been developing. Kristen mentioned that we're behind. There's more than a decade of work on this internationally, and some of the red flags, I guess, that have been identified in the literature and in practice in property include, for example, unexplained wealth used to purchase property, where the client's income that you're aware of is disproportionate to the transactions that are occurring. The client might, for example, purchase several residential properties without financing over a short period of time. None of these are definitive. These are potential red flags that might indicate that there is money laundering or terrorist financing happening. Perhaps your client isn't directing decision making, or there's uncertainty about who the real beneficial owner is. And perhaps there are mortgages being repeatedly repaid quickly or significantly before the maturity date with no apparently logical explanation. Changes might occur just before settlement in the instructions you receive. The client might inexplicably demand to settle a conveyance or a sale in an extremely short period of time with no apparent justification. And finally, the client might request to ask to deposit funds very early or significantly in excess of what's required for a transaction, and the obvious ramification there is that would come back to someone somewhere, and that could be laundering as well.
Thanks, Lana. I might take over from there. So as you can see, we're talking here a little bit about a Shane Budden-esque army worthy of Mordor's dark deeds. What we're also talking about here is a compliance regime, and in Australia we already have an AML-CTF regime which exists, but it doesn't apply to lawyers at the moment, accountants, real estate agents or people in the sector that we're dealing with. And what we're here to talk about today is some moves to potentially extend that into our industry. So AML-CTF was created in the 80s as a part of the war on drugs. There was a scene to be able to stop that illegal money getting into the legitimate financial system. In Australia, in 2006, we got the AML-CTF Act, Commonwealth legislation. It commenced in 2008. It was regulating at the moment here in Australia, really looking at the gambling, financial services and remittance service industries. And what it has is what they call Tranche 1, that deals with the financial services industries. And what we're looking at there is obligations for people that are regulated entities to be able to identify and verify the identity of clients that they have, to be able potentially to make reports to AUSTRAC, who's the regulator, if there are suspicious matters in particular transactions, also to report certain threshold transactions. Already we have a cash $10,000 transaction requirement. That's also in part of the AML-CTF regime, as well as international funds transfers in certain circumstances. In that regime, there's a requirement to report suspicious matters to AUSTRAC, but also not tip off the person who's the client that the report's been made, and that's important for later on. One of the other obligations is to maintain an AML-CTF program, which is a program to take matters and identify the risk in those matters and take particular types of due diligence steps to deal with the risks, and to be able to apply measures to know where the source of funds are, and to be comfortable that the transaction that we're dealing with is not dealing with the proceeds of the terrible stuff that Lana's talked about. And then there's staff training obligations and there's record keeping obligations with respect to documents. So it's a big regime and it's quite hefty, and you will have seen banks get fined hundreds of millions of dollars for not doing a very good job of it over the period of the past time, and you will have also probably experienced banks then afterwards going, crikey, we better do something about this. Let's go send out letters to people.
And some of you might have got the letters. That's what I was just going to say, Matt. Who's had one of those letters that's, got a list of names on it, and then all of a sudden you're not meant to be taking funds into your trust account from one of them? And I know that's happened on a couple of developments that I've worked on, which is a bit of a shock to quickly notify the developer that something might not be settling where a lot's under contract. So that's definitely where I've seen it.
Yeah, and so they've certainly picked up a lot of what they're doing in this particular space as a response to that. So 2008 was when those obligations came in on the financial institutions. In 2007, there was an expectation that those obligations in Australia would be extended to lawyers and real estate agents and accountants. That was called Tranche 2. That didn't end up happening because of the GFC and the advocacy of the legal profession. Post-GFC, there was another investigation and another go at doing it in 2012 and another one in 2016. None of that yet had come to pass with respect to Tranche 2, but it was always sort of seen as unfinished business from the initial rollout of the scheme. Those who are regulated say that because the lawyers and accountants and real estate agents aren't regulated and aren't doing these checks, there's a big hole in our system. And so that sort of puts us up to today. We have a bit of an opportunity to take a bit of a look into what it looks like. As Christian said, in 2018, the lawyers in New Zealand became reporting entities for the purpose of domestic AML-CTF with their legislation. Probably what's interesting is this is a big issue, and it has been a big issue since 2006, and it's been one of those latent ones that's a bit of a sleeper that's been in the background. Look, QLS has always had a very strong position about being concerned about additional compliance obligations on legal practitioners, particularly if they're ineffective. And we've always wanted an effective solution to this problem of money laundering. Ultimately, there's an ethical problem in this space which is not being used as an instrument of fraud and not to perpetuate something which is otherwise illegal. So that's kind of a fundamental ethical tenet that undersits this. But reasonably, the way this scheme needs to roll out is in a way that doesn't jeopardise the fundamental tenets of the legal profession as being officers of the court, and also doesn't make it so unviable to be able to conduct a practice that people will leave legal practice or leave the regulated areas. Real estate is one of those, conveyancing is one of those, so that's kind of as it is. So that's the balancing act that we're in. At the moment, let's see the journey. That's what's happened in New Zealand. Here in Australia, 2015, that international body, FATF, did a mutual evaluation of Australia and said, hey Australia, you are an outlier with the rest of the world because your legal profession, your real estate agents and your accountants aren't regulated, and they should be, and your defence against the evil of money laundering is lessened. And the Australian government got very embarrassed. As they had been at every other mutual evaluation on that particular issue. In 2016, there was a statutory review of AML-CTF where the government said, cripes, it's about time for us to do something about regulation of Tranche 2, but jeepers, it seems complicated and difficult. In 2022, there was a Senate committee inquiry on money laundering and counter-terrorism financing. That was an inquiry that was proposed and pushed by the Labor majority in the Senate. So even though the government of the day wasn't of in kind, that's the government we're dealing with now. And that government and that Senate inquiry resolved that there should be an expedited consultation on Tranche 2. And so that's then brought us to the joy of this particular year. And so in June this year, the Commonwealth Government released a discussion paper on some of the high-level aspects of looking at Tranche 2. They had some roundtable sessions. The Law Council Australia that Lana works with has gotten into the trenches to go, this is not easy, it's not simple, it's not straightforward. If there is to be any system, it's one that has to be tailored, it's got to be minimised, it's got to be focused, it's got to be effective. We're looking at a second consultation paper. I think it's probably fair to say government's flagged its intention, the Commonwealth Government, that they will just legislate this to bring it in, regardless of what anybody says, unless, of course, we have a double dissolution before then. Or something else terrible happens. But this is firmly on the current government's agenda to progress. So, you know, we've got an interesting landscape at the moment, and a lot of the work that Lana's doing, and I'm working on a Law Council working group as well to this, is to try and figure out what is a scheme which can be as focused and as minimised as possible from what you described there, Kristen's really good questions, really good complicated issues, and the government needs to understand that legal practice is not like running a bank. Legal practice is a lot more complicated than that, and there's a lot of variety and difference, and you can't just do broad brush extensions, I think is probably one of those things. Lana, what do you...
Well, all I'd add to that, I agree, Matt, and just to let you know that the Law Council has lodged quite a substantial submission to the first round consultation and is working behind the scenes very hard to prepare for the second round, because, as Matt said, it's looking quite clear that this is coming this time. But the question is going to be, what does it look like? And there are many permutations possible. One thing that is really central to the Law Council's views and its constituent bodies and the profession is that conveyancing and property work is bread and butter and really critical to the work that this profession is engaged in for many reasons. And so we're looking really closely at the pathway of a conveyance, at the relationship between the different parties, an accountant, a real estate agent, a bank, and how to manage and ultimately translate into sensible legislation, if that's what happens, which is looking very probable, a situation where people aren't duplicating the work and so costs aren't spiralling out of control. So there's a lot of really detailed work and one of the challenges is getting on the same page with government and, as Matt suggested, really making sure that the people with whom we're dealing understand the reality of daily practice and how costs affect your ability to make decisions that aren't stressed and full of fear and concern about what the next step is. This has to be a rational and proportionate agenda, and that's what we're working towards. We think there's going to be draft legislation at the beginning of next year. So in a way, this is moving at some speed. Nevertheless, in contrast to the situation in New Zealand, where it was rushed in, we actually are having meaningful consultation with the government, and that's a real positive.
Very much so.
Yeah, thanks, Lana. I think I would speak for everyone here that we're grateful that we've got people like yourself and Matt to speak, because I know that, I mentioned our sort of risk person before. Not every firm is fortunate enough to have the person that can run around and, speak to people in New Zealand and work out what's coming and plan for the future. And we certainly don't have the resources of the large banks to be able to deal with that. So I think, you hit the nail on the head there, that's going to be potentially a significant issue.
Yeah.
Can I just add that I think, though, out of all of that message, which is probably a bit scary, and we've got other things that are probably more scary, especially the stories of solicitors that have gone to jail in the UK for doing conveyancing work, but which we won't scare you with now. But
you'll need that drink afterwards.
You'll
for
need
sure.
that. I'll tell you those stories afterwards. But I think can I just say there's two reasons I think for hope out of all of this. And I think there is some
We
hope.
should definitely finish on some
I think
hope.
we should finish on
Yes.
hope. And we should, I think there is two reasons for hope. And that Senate review process that occurred last year, Law Council was there in the corner, was fighting in the trenches. A lot of folk were in the trenches and things. And two of the important outcomes of that review was that there was a real acceptance that any particular money laundering regime in an Australian context had to be conscious of the fact that Tranche 2 would be affecting small businesses, and that small businesses are not like the large financial institutions. And I think that's an important thing, because what Neil talked about from New Zealand was a very different approach, where there was an absolute panic. When the Panama Papers came out in New Zealand, there was a number of law firms in New Zealand mentioned. In fact, I think even at the time, the current Prime Minister of New Zealand was also mentioned in the papers as well. And it was a big deal for the government there. And so they just hit it with a giant hammer to smash it into smithereens. and they dumped over it the current regulation that existed for the financial institutions. And then since then, they've been carving it back over 5 years, carving out bits, making it work, focusing it a bit better, taking out this, putting this in, and still tinkering and changing with it to try and get it a bit more focused. And what we've said to government this whole time is that that's a really bad way of going about things. Just deeming everyone to be in for everything and then working out the details afterwards is a really ineffective and difficult way, because legal profession has, like they have in New Zealand, have had to come to the full scope and then start to walk it back. And I think the other part that's really important about the Senate review was that they said that the scheme had to be effective. And there's been a lot of concern up to this point that in Australia the money laundering scheme hadn't been perhaps as effective as it could be at stopping money laundering, and probably the hundreds of millions of dollars of fines of the banks for non-compliance and not picking up stuff was probably a good indication that the scheme wasn't quite working as well as it should be. So if there's any hope I think we can take from the whole scenario is that there is, at least with government here, an indication that small businesses will be impacted, and so it can't be just the giant hammer that was swung in New Zealand, and it has to be done in a far more sensible and a far more nuanced way. The difficulty that Lana has is then trying to translate the complexity of the types of scenarios that Kristen talked about, the types of scenarios that you see on a daily basis to public servants who have never done a residential conveyance in their life, except they've paid someone else to do one, when they're designing a scheme, and then also making sure that the scheme itself is tightened up to actually work. Because if we're contributing to something that's actually going to stop money laundering and the financing of terrorism, then that's probably a good thing. But the worst case scenario is where we get a whole lot of compliance obligations which ultimately don't even really achieve that, but everyone just has to do them. So I think we've got two really good places for hope in this, and I think those are two guiding principles that are underpinning what's going on now and are probably an important part of the future, which means that the result that we get, if we get a result, that will be a far better result than in any of the other jurisdictions in the world that have had this. And I think in terms of jurisdictions in the world, the only places where the legal profession doesn't have this obligation, the only places at the moment are the United States, Canada,
Yes.
China,
However,
and
all I'd say is
Mongolia?
that I think Haiti
as well. There's a very
yeah, there's
limited
significant
number of
political pressure
places. In those places as well.
well, everywhere, and certainly on this government to legislate. And I would just say that one of the key factors that will stop the government from being embarrassed and potentially grey-listed, so which has ramifications for a credit rating for a nation. So the stakes are pretty high. The Financial Action Task Force is quite a powerful body. And one of the factors that influences their work is, apart from whether a regime is in place, it's whether entities that are considered to be at risk of exploitation, so that's us included, are aware of their risk. And in the last mutual evaluation that was conducted that Matt referred to earlier, it was found that lawyers generally were not aware of the risk of their practices being misused. And so that's a part of the work that the Law Council has been working on behind the scenes. Hopefully there'll be some results of that by the end of the year to just produce some tools and to start talking at a very high level, because we don't have legislation, but just about red flags and building on the work. Can I say that the Queensland Law Society has done brilliantly over past years while there's been this hiccuping sort of stop-start approach to the policy reform.
Yeah, thanks, Lana. I think I don't think anyone wants these these money laundering practices around, and the comments around obviously rationalising have nothing to do with the fact that we know those practices occur, and I don't think we want them in our society. It's coming. QLS are onto it, and Law Council, so thank you. And you will hear more from QLS in relation to that.